A 5-4 Supreme Court decision changed gun law in America so fast, most people still misunderstand what it actually did. And if you think that ruling means every gun law is now dead, or that your rights work the same in every state, you could be making a very dangerous mistake. Pause. Quick question before we continue. Are you subscribed? Because this channel breaks down the court rulings, state changes, and legal traps that can catch gun owners off guard. If you want simple, straight answers instead of confusing lawyer talk, hit that subscribe button right now. Let's get right into it. The case was District of Columbia versus Heller in 2008. The vote was 5-4. And yes, it really did shatter a huge gun law assumption overnight. Before Heller, a lot of courts and legal experts treated the Second Amendment like it was mostly tied to militia service. In plain English, that meant many people believed the amendment was mainly about organized military duty, not your personal right to keep a gun for self-defense in your home. Then Heller dropped and the Supreme Court said, no. The Second Amendment protects an individual right to possess a firearm for lawful purposes, especially self-defense in the home. That one sentence changed everything. Here's what just happened in that case. Dick Heller was a D.C. special police officer. He wanted to keep a handgun at home, but Washington, D.C. had a handgun ban. It also had rules that made lawful firearms in the home basically unusable for quick self-defense. If a gun had to stay unloaded or locked up in a way that stopped you from using it when danger showed up, that was a major problem. The court looked at that and said the government had gone too far. Now, this is where it gets interesting. The court did not say every gun law is unconstitutional. It did not say you can carry anything, anywhere, anytime. And it definitely did not say states can't regulate guns at all. What it said was narrower, but still massive. It said the government cannot wipe out the core right of a law-abiding person to keep a functional firearm in the home for self-defense. That was the earthquake. Think about why that mattered. Imagine you're home at night. Your door gets kicked in. You hear footsteps. Your phone is in one room. Your kids are in another. In that moment, a gun that is banned, disassembled, or locked so tightly you cannot use it is not really a self-defense tool. It's a paperweight. The court understood that point. But here's the crazy part. Many people still get Heller wrong in both directions. Some anti-gun voices acted like Heller made all regulation impossible. That was false. Some pro-gun voices acted like Heller created a totally unlimited right. That was also false. The court itself said the right is not unlimited. That line matters a lot because it keeps showing up in later cases. So if you only remember one thing from Heller, remember this. The case recognized an individual right, but not an unlimited one. And that leads to the first big myth this case destroyed. First thing, Heller destroyed the idea that the Second Amendment only mattered if you were in a militia. Second, it destroyed the idea that a city could completely ban handguns in the home and still claim it respected self-defense. Third, it destroyed the idea that a firearm can be made legally useless and still count as protected. But wait, there's something even more important. Heller did not automatically fix the whole country. A lot of people miss that part. D.C. is under federal authority. So after Heller, the next question was obvious. Okay, but what about your state, your city, your county? What about Chicago? What about California, New York, New Jersey, Illinois, Maryland, Hawaii? Did Heller apply there too? At first, that answer was not fully settled, and that's where the next shock came in. 2 years later, in McDonald versus Chicago, the Supreme Court again ruled 5-4. This time, the court said the Second Amendment right recognized in Heller also applies to state and local governments through the 14th Amendment. Let me break this down for you in normal English. Heller said the right exists. McDonald said states and cities have to respect it too. That was huge, because before McDonald, someone could try to argue, sure, the federal government has limits, but local governments can still do what they want. McDonald slammed that door shut. If you're finding this helpful, imagine what you'll learn in my next video about the simple mistakes gun owners make when they talk during a police stop. Subscribe now so you don't miss it, because one bad sentence can cause a lifetime of trouble. Now, let's talk about the part nobody likes to admit. A lot of people hear individual right and stop listening there. That is how bad assumptions get built. That is how people end up overconfident. And overconfidence around gun law is dangerous. Here's what most people get wrong. They think Heller and McDonald mean any gun rule they dislike must be unconstitutional. That is not how the court framed it. The court protected the core right of self-defense. It struck down a handgun ban in the home. It rejected a rule that made lawful guns useless in the home. But it did not erase every rule on permits, possession by prohibited persons, sensitive places, or dangerous conduct. Most people think the story ends with gun owners won. But the truth is more complicated. The court opened one door and left many others for future fights. Here's a hypothetical example to explain this. Let's say a town passes a rule saying you can own a handgun in your home, but it must be stored in a way that makes it impossible to use during an emergency. Heller gives you a strong argument against that rule. Now imagine a different law that says a violent felon cannot legally possess a firearm. That is a different legal issue. Heller did not wipe out that kind of rule. See the difference? One attacks the core right of self-defense for ordinary law-abiding people in the home. The other deals with limits the court has often treated differently. This is the part that shocked me when I first studied it years ago. The biggest Supreme Court gun cases are powerful, but they are not magic. They do not solve every question. In many ways, they create new questions. Then came Bruen in 2022, and Bruen took the story even further. Bruen said the right to bear arms is not stuck inside your front door. The court said the Second Amendment generally extends beyond the home to public carry, and it told courts to judge gun laws by looking at the text of the amendment and the nation's historical tradition of firearm regulation. That sounds fancy, so let me simplify it. Judges cannot just say, "We think this law seems reasonable." They have to ask whether the conduct is covered by the Second Amendment's text, and if it is, whether history supports that kind of regulation. That changed the legal battlefield again. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And then came another twist that many viewers never hear about. In 2024, the Supreme Court decided United States versus Rahimi. A lot of people expected that case to explode modern gun restrictions. Instead, the court said a person under a qualifying domestic violence restraining order, where a court found a credible threat, can be temporarily disarmed. Read that carefully. Rahimi did not abandon Heller or Bruen. It actually repeated that the Second Amendment is a real constitutional right. But it also repeated something just as important. The right is not unlimited. So if someone tells you, the Supreme Court said no gun restrictions are allowed now, that person is flat wrong. And if someone tells you, the Supreme Court said the Second Amendment means nothing, that is also flat wrong. The truth is right in the middle, and that's why this stuff is so easy to mess up. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community of gun owners and legal watchers who want the facts before the rumors spread. Click subscribe, because these court decisions move fast, and the headlines usually get them wrong. Now let's talk about why this matters to you in real life, not just in a courtroom. Have you ever wondered why two gun owners can read the same Supreme Court headline and come away with totally opposite ideas? One thinks every law is dead, the other thinks nothing changed. The reason is simple. They're reading emotion, not the actual holding. Here's how that creates real danger. Imagine you move from one state to another. You assume Heller means your home gun setup, storage rule, permit process, and local restrictions are all basically the same. They are not. Heller gives you a constitutional floor, not a nationwide copy and paste rulebook. Or imagine you hear that Bruen expanded carry rights. So you assume every sensitive place rule is automatically fake. Wrong again. Courts are still fighting over what counts as a sensitive place, what historical laws matter, and how broad those restrictions can be. Or picture a friend telling you, "Don't worry, the Supreme Court already settled that." And be careful with that advice. A case can settle one issue while leaving 10 others open. That is why assumptions are so dangerous. Let me give you the simple version. Heller said the Second Amendment protects an individual right to keep a firearm for self-defense in the home. McDonald said state and local governments must respect that right too. Bruen said the right to bear arms generally extends beyond the home and set a history-based test for reviewing gun laws. Rahimi said, even with those protections, the government can still impose some limits that fit historical tradition, including temporary disarmament of people found to pose a credible threat. That's the chain. Now, here's the part nobody talks about enough. Supreme Court wins do not instantly rewrite every lower court, police department, licensing office, and city code in America. Change takes time. Cases keep getting filed. Old rules get challenged. New rules get written. Some survive, some fall. So don't make this mistake. Don't hear one headline and act like you now know the entire law in your state. If you don't know this, here's what could happen. You rely on bad internet advice. You transport the wrong firearm the wrong way. You carry in a place your state still treats as restricted. You ignore a local rule because someone online said, "Bruen killed that." Then suddenly, you're the test case. And trust me, being the test case is not fun. Most people want certainty. Gun law usually gives you layers instead. Federal law, state law, local rules, court rulings, permit systems, prohibited person rules, location restrictions, and factual details all matter. That is why this 5-4 decision matters so much. It shattered the old assumption that the Second Amendment was only about militias. But it also created a new trap. People started assuming the right has no limits. The Supreme Court never said that. And that balance matters more than ever right now because lower courts are still sorting out bans, carry laws, age rules, serial number issues, sensitive places, and who can be disarmed under the Constitution. Laws change fast. Court rulings change faster than most people realize. Subscribe now, because in the next video, I'm breaking down the exact parts of these gun cases that people misquote the most. And one of them could affect how you think about carrying, storage, and self-defense today. So here's the takeaway. That 5-4 ruling in Heller changed the country by recognizing that the Second Amendment protects an individual right to have a functional firearm for self-defense in the home. McDonald spread that protection to the states. Later cases expanded and clarified the rule, but they also made clear the right is real and the right is not unlimited. If you remember that, you're already ahead of most people arguing online. And if you want clear updates without the noise, the politics, and the fake panic, subscribe right now and stay with this channel. I do the research, so you don't have to. Final simple disclaimer. This video is for education only. It is not personal legal advice, and laws can be different depending on your state and your facts. If you have a real legal problem, talk to a qualified attorney before you act.